Hello, welcome once again to Lehto's Law. I'm Steve Lehto. Today we're going to talk about false arrest. What is false arrest? Can you sue somebody for false arrest? When can you sue somebody for false arrest? I'm bringing this up because it's a common topic. I see people talking about it in the comments below my videos from time to time, and I've also seen it in the videos of people who get pulled over by the side of the road, and when the police officers ask them for information or detain them, they'll often start screaming about false arrest. So it's important that we know what false arrest is and when, in fact, you can sue somebody for it. So I'm going to direct your attention to a case out of Michigan that's interesting. A jury in a U.S. District Court has awarded a Harper Woods man $3.5 million 6 years after he was mistakenly arrested by Detroit police in connection with a drive-by shooting. The payout to 43-year-old Marvin Seals is thought to be the largest award for a wrongful arrest case in Michigan history. Seals' lawsuit was filed in 2012, but the city's bankruptcy, Detroit went through bankruptcy, and numerous appeals stalled the case to where it only got tried in the summer of 2018. On Friday, following a 4-day trial, an 8-member jury took less than 2 hours to deliberate before unanimously awarding Seals $3.5 million, which is also possibly going to get larger because it could increase by as much as $1 million if the judge awards the attorney fees to the plaintiff. Seals' attorney is James Harrington, and I have to double check that because I had a student named James Harrington a few years ago, and if this is James, congratulations, my good student. He said it was a gross injustice of what happened to his client, and here's how it went down. In 2012, members of the Detroit Fugitive Apprehension Team arrested Seals at his job at a food service in Warren in connection with the 2010 drive-by shooting. Police insisted Seals was using a fake identification card, and they claimed his real name was Roderick Signer, the man investigators thought was responsible for the shooting. One of the aliases that Signer was known to use was Marvin Seals. Seals lost his job, repeatedly told the officers they'd got the wrong guy, and according to the lawsuit, this stuff was all made known to the police. So Seals was charged with assault with intent to commit murder. He sat in Wayne County Jail for 15 days before a preliminary examination, and during the hearing, the victim got a look at Seals and told the prosecutors, "That's not the guy." The lawsuit accused arresting Officer Tom Zaburkot and Wayne County Jail staff of failing to look at an available mugshot they had of Signer, which would have shown them they had the wrong guy. At the time of Marvin Seals' arrest, a mugshot and further identification of Roderick Signer was available to Zaburkot, but according to the lawsuit, Wayne County Jail officials had access to the mugshot but didn't bother looking at it. After Seals was released, Signer was actually arrested in July of 2012 and charged with assault with intent to commit murder. Those charges were later dismissed. And in 2015, Signer, who at the time was on probation in Alabama for an unrelated crime, filed a lawsuit in federal court claiming he'd been falsely arrested for the 2010 shooting also. But his lawsuit was dismissed. Okay? So keep that in mind. Seals' lawsuit has taken several twists and turns. When the city declared bankruptcy in July, the suit was stayed. It was reopened in 2015, and the city then filed several appeals. Zaburkot argued during one appeal that at the time it was reasonable to conclude that Seals was the person identified in the warrant and that the arrest was not unreasonable seizure rising to the level of a civil rights violation. That went up to the U.S. Sixth Circuit Court of Appeals, and they ruled that the lawsuit could proceed, and they sent it back down for trial. And the Sixth Circuit opinion reads, "There's no evidence that the officers made any attempt to verify Seals' identity. Nothing suggests that the officers checked Seals' fingerprints, photographs, or biographical information against the information that they had on Signer." So the jury awarded Seals $750,000 because his Fourth Amendment rights were violated, $500,000 for the wrongful imprisonment, $250,000 for the false arrest, and $500,000 for gross negligence, and $1.5 million in punitive damages. So that all adds up to $3.5 million for the wrongful arrest. So what really got me thinking about this in the first place, though, is I see these videos on YouTube, and I also get comments below my videos, where people say, well, when the police officer pulls me over, I'm going to sue him for false arrest. And I also see videos of people when the police officer pulls them over and says, can I see your driver's license and registration? They go, am I under arrest? And they go, no. They go, well, am I free to leave? No, I'm detaining you until I can determine whether you have a driver's license or not. And then the person will say, well, I'm going to sue you. I'm going to sue you for false arrest, and I'm going to win, and I'm going to get all kinds of money. And it's funny because they always say they're going to, but of course they never do, or if they do, the lawsuits get thrown out. But you need to understand a couple things about false arrest. And like I said, a lot of legal terms get tossed around, they get bandied about, and many people don't know what it means. So generally speaking, a false arrest is when one person holds another person against their will. You might say, does that sound a lot like kidnapping? Well, kidnapping is a slight variation on that. That's where you hold somebody against their will and then you move them against their will, at least at common law. But generally speaking, the more common false arrest you hear about is where one person takes another person into custody without consent and without legal justification. So if you consent to it, it's not a false arrest. But the key here is without legal justification. What is the legal justification to take another person into custody? And so you're often hearing about the cases of false arrest being made against police officers and often against private security companies. You're at the mall and a mall cop walks up to you and says, hey, I think you did something wrong. I'm going to arrest you. And we're going to consider that like a citizen's arrest, which I've talked about before also, or whatever. And they hold you against your will. Well, if they did that without legal justification, it could rise to the level of false arrest. And by the way, when I told you the facts of the case where the man got $3.5 million, remember there were egregious facts there. Besides the fact the guy got locked up and charged with a crime and he clearly was the wrong guy, if somebody detains you for 5 minutes and then lets you go, yeah, that's 5 minutes of your life you can't have back. But are you going to be able to sue and get $3.5 million for it? Probably not. Okay, so we're always talking about liability and damages. But again, the idea is somebody takes you into custody without consent or without legal justification for doing so. And so there's some elements to this, but you have to remember one thing, and that is that there's a false arrest concept that comes from the federal statutes. Okay, it's a USC action. It's under the United States Code. 42 USC 1983. You'll often hear people say a 1983 action, and I'll get to that in a second. But there's also the possibility of a common law cause of action for false arrest. And in Michigan, they've actually got a common law action called unlawful imprisonment circumstances, and it's a violation, becomes a felony, and so on. It's got penalties and so on. But that's an actual state statute. But you're also going to have in every state the possibility of a federal action under 1983, assuming that the person who's doing this to you is a government actor. So I've tried to explain this in previous videos. Not everything that anyone does to you qualifies as a constitutional violation. The Constitution generally restricts the federal government, and then by the 14th Amendment, state governments, from taking away your liberties and rights. Okay, and it speaks to the government as an actor. There are some situations where you can make out a case, but generally speaking. So if a total stranger comes up to you for no reason and grabs you and holds you and says, I'm taking you into custody, and they're not a police officer, they're not a security guard, they're not doing it under any color of law, they're just doing it. Okay, that's not going to qualify as a 1983 action. However, it would qualify as an unlawful imprisonment action under state law. So even if you don't qualify under the federal law, it doesn't mean you don't have a cause of action. It just means you don't have that cause of action. So if somebody confines you, okay, the defendant confines you, and you become aware that you are confined, and you say, well, that's a weird distinction, but I'll get back to that in a second. And you did not consent to being confined, and there's no excuse for the confinement. There's no privilege there. Then you have a prima facie case to make out against somebody for false arrest. If they are a government actor, you can then seek to go after them for your violation of your civil rights under 1983. But if they're not a government actor, you go after them under state law. Okay, so somebody confines you. Okay, that can be a very broad term. If I locked you in a room, I handcuffed you, things of that nature. You've got to be conscious of the confinement, and a lot of law professors and scholars will make up hypothetical situations, and once in a while they happen in real life, but there's oddball stuff. But let's suppose that you broke into my house and you were drunk, broke into the wrong house. and you went and you fell asleep in my bedroom, not realizing that it wasn't your bedroom. And I come home and hey, there's a strange weirdo sleeping in my bed. So I lock the door and I call the police. Police come and haul you away. And as you're blearily waking up, you realize, wait, I was locked in that room for 6 hours? Well, you didn't know it, so you can't go after me for false arrest or false imprisonment. So you got to be aware of it, and you must not have consented to it. But the confinement was not privileged. And the privilege that somebody would have to arrest you is, generally speaking, if they're a police officer and they've got probable cause, or if they have a warrant. Because as you know, searches and seizures are unlawful if they are without probable cause or without a warrant. But if they've got a warrant or they got probable cause, then you can't claim you were falsely arrested. Okay? So the idea, obviously, stems from the notion that we can't go around locking people up for no reason, and that makes complete sense. But if you are going to claim that the police officers arrested you wrongfully, the first question you've got to ask is, did they have a warrant? And if they didn't, did they have probable cause? So if they have a warrant, that's a yes or no. Did they have a warrant? Yes. Okay, they got you. Unless, of course, they got the wrong person with the warrant. So the warrant better apply to you. And right now I'm pointing at the article from the Detroit News. But probable cause is actually the grayer area. So let's suppose someone calls the police and goes, hey, there's a guy in my front yard and he's attacking somebody, and they describe you. And the police show up, and there's only one person that meets that description. And they talk to you, and they talk to whoever it is that called it in. They go, yeah, that guy's been attacking people. He's beating people up. He's hurting people. And the police arrest the person based on the statements made to them by witnesses that appear to be credible that this person's attacking people or what have you. And that's probable cause to arrest somebody. If somebody says, yeah, I'm a witness. I saw it. What I'm saying to you seems credible. And a police officer could arrest somebody based on that. Okay, they examine the circumstances and facts, and they go, yeah, we got probable cause. But you hear about these cases where the police didn't quite have probable cause, and they show up and they're doing a little investigation, and they just arrest somebody. And so the question is going to become, did they have probable cause? And I'm not going to get really heavily into what probable cause is, because number one, no one will agree with me if I do. And number two, it's not really that important, except that you understand that the probable cause is recognized by the courts as having a gray area, meaning that what you might consider probable cause and what I might consider probable cause might be slightly different, okay? And so the police have what they call qualified immunity, and they do get some discretion. Now, they don't get complete discretion. They can't just say, you know something, I walked down the street, this guy gave me a dirty look, and I arrested him because I think he committed a crime, and I had probable cause because he gave me a funny look. Well, obviously, that's so far beyond what any reasonable person would think, would make sense, that's going to be beyond the realm of their discretion. But the courts recognize that police officers are actually dealing with situations in the streets, figuratively speaking, where they're out there dealing with criminals and crime scenes and the accused and so on. And so sometimes they might make a slight error in one direction or the other. And if they make an error that hurts you, the question then becomes, did they make a reasonable but mistaken judgment about something? In other words, was it reasonable? Even if it was mistaken, was it reasonable? But it does not protect the plainly incompetent or those who knowingly violate the law. So a police officer cannot just act incompetently and say, well, I arrested the wrong person. Oh, mistakes are made. No, that's gonna be a problem. But the question is, did they make a reasonable but mistaken judgment about something? And that's going to be the question. So if a police officer mistakenly arrests you, but had a good reason for doing it that could be looked at as being a probable cause, then you're going to lose the lawsuit if you file it. So this idea that a police officer pulls you over and walks up to your window and says, hey, driver's license and registration, and you go, why? And the police officer says, well, here in Michigan, you've got to provide that when I ask you to provide it. If you say, well, am I free to go? And the police officer goes, no, of course you're not free to go yet. Show me your driver's license and registration and proof of insurance. They say, well, if I'm not free to go, I must be under arrest then, right? Police officer goes, no, you're not under arrest. I'm simply detaining you. This is a traffic stop, and I'm trying to ascertain whether you have a driver's license as required by state law. And what happens then is people will often say, well, this is a false arrest. I'm going to sue you and I'm going to own everything you own and you better have a bond and blah, 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 blah. And I'm going to sue you under 1983. Now, 1983 is a section of the U.S. Code, 42 U.S.C., where it says every person who, under color of a statute, ordinance, regulation, custom, or usage, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, except that any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity. Injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. For the purposes of this section, any act of Congress applicable exclusively to the District of Columbia shall be considered to be a statute of the District of Columbia. But basically speaking, anybody acting under color of law or authority of law who violates your constitutional rights is violating that section. You can sue them under that. So as we go back to the original case I talked about, the man who was locked up when he clearly was the wrong guy, they didn't even look to see if he was the right guy. Yeah, his rights have been violated. He can sue under that. But if it's not a state actor, it's simply somebody who falsely imprisons you. Well, like I told you before, there's a state statute on that in Michigan and probably in your state as well. MCL 750.349B. A person commits the crime of unlawful imprisonment if he or she knowingly restrains another person under any of the following circumstances. The person is restrained by means of a weapon or dangerous instrument. The person restrained was secretly confined. The person was restrained to facilitate the commission of another felony or to facilitate flight after commission of another felony. And a person who commits unlawful imprisonment is guilty of a felony punishable by imprisonment for not more than 15 years or a fine of not more than $20,000 or both. So this section does not prohibit the person from being charged with, convicted of, or sentenced for any other violation of law that is committed by that person while violating this section. So if you falsely imprison somebody in Michigan and you're not a state actor, you can still be charged with this, and it's a felony for which you can go to jail. I believe there's also a civil side to this, meaning you can sue somebody if they falsely imprisoned you. You'd be suing them under a state law, not under federal law. So the real question is, again, talking about false imprisonment and wrongful arrest and so on, is did they take another person into custody, that's you, without consent or without legal justification to do so? And so they have to have taken you into custody without legal justification. And by the way, in case you're curious, failure to display your driver's license at the side of the road in some states can get you arrested. So they'll take you into custody for not displaying your driver's license. And you can then go into court and scream and yell all you want about how you've been wrongfully arrested and you want $3.5 million in actual and punitive damages. And the court will throw your case up because they'll say, couldn't you have avoided this by simply displaying your license as you were required to by law? So that's what you need to know about wrongful arrest. It's obviously a bad thing. You hope it never happens to you. But no, when you get pulled over to the side of the road and a police officer asks you for your driver's license, that's not a wrongful arrest. Questions or comments? Fire them my way. Otherwise, talk to you later. Bye-bye.